Julian Assange, February 2024 hearing update. So what is the latest Assange hearing in February 2024 about? Please subscribe. Like, follow, and share. Don't forget, thanks. The United States government's prosecution of Julian Assange represents an attempt to punish Assange and Wikileaks for exposing the criminality of the U.S. government on a massive and unprecedented scale. Lawyers for the Wikileaks publisher told two senior judges at the British High Court of Justice. Crimes allegedly exposed by the Wikileaks publications that are central to this case include torture, extraordinary rendition, and drone strikes that allegedly killed scores of civilians. Assange is seeking permission to appeal District Judge Vanessa Baraitser's extradition decision, which was issued in January 2021. Barristers Mark Summers KC and Edward Fitzgerald KC set out 7 grounds for challenging the ruling. The US-UK extradition treaty clearly prohibits extradition for political offenses. The offenses Assange is prosecuted with, namely espionage, fall into the category of pure or self-evident political offenses. It was an abusive process for the U.S. to seek the extradition of Assange for political offenses. Extraditing Assange in violation of the extradition treaty would result in detention which is arbitrary and in violation of Article 5 of the European Convention on Human Rights, ECHR. Extradition would represent a flagrant denial of his right to freedom of speech under Article 10 of the ECHR, including the possibility that he will be denied protections under the First Amendment of the U.S. Constitution. Allowing Assange to be prosecuted under the U.S. Espionage Act when no other journalist or publisher ever has been violates his Article 7 right not to be prosecuted for acts which did not constitute offenses at the time of his actions. Assange would not receive a fair trial in the U.S. Defense lawyers maintained that Baraitser had improperly interpreted the law and ignored key information that was brought to her attention. They also sought permission to introduce fresh evidence as part of their appeal. In particular, the defense noted that Yahoo News had reported allegations that plans to kidnap or assassinate Assange were considered by high-ranking officials at the CIA and in President Donald Trump's administration. As Fitzgerald recalled, the decision to target Assange by extrajudicial means denied protections under the First Amendment of the U.S. Constitution. Allowing Assange to be prosecuted under the U.S. Espionage Act when no other journalist or publisher ever has been violates his Article 7 right not to be prosecuted for acts which did not constitute offenses at the time of his actions. Assange would not receive a fair trial in the U.S. Defense lawyers maintained that Baraitser had improperly interpreted the law and ignored key information that was brought to her attention. They also sought permission to introduce fresh evidence as part of their appeal. In particular, the defense noted that Yahoo News had reported allegations that plans to kidnap or assassinate Assange were considered by high-ranking officials at the CIA and in President Donald Trump's administration. As Fitzgerald recalled, the decision to target Assange by extrajudicial means was reportedly driven by Wikileaks publishing the Vault 7 materials in March 2017. The files exposed the CIA's cyber warfare and hacking programs, and 1 month later, CIA Director Mike Pompeo labeled Wikileaks a hostile non-state intelligence service. His attorneys also raised the fact that Assange could face the death penalty, something which is prohibited by law in the United Kingdom. Without assurances from the U.S. government that the death penalty would be off the table, his extradition should not be permitted. The US-UK extradition treaty should bar extradition. When the High Court previously decided that the award-winning Australian journalist could be extradited, the court did so after receiving diplomatic assurances from the US government that he would be treated in a manner that would prevent suicide. Assange's attorneys immediately sought permission to appeal the many arguments that Baraitser had overlooked. In their view, by failing to consider the prohibition of extradition in relation to political offenses, Baraitser ignored an age-old prohibition, which has been included in virtually every UK extradition treaty. It is one of the most fundamental exceptions recognized in international law, and it is included in treaties with 156 out of 158 countries that the UK has treaties with, Fitzgerald explained. There is a massive body of case law decided by UK, courts as to what constitutes a political offense, there is a massive body of case law decided by UK courts as to what constitutes a political offense, Fitzgerald added. But Bereitzer did not consider any of this because a 2003 extradition law was silent on the matter of political offenses. The district judge interpreted the statute's silence on political offenses as meaning that UK Parliament intended to remove the political offenses exception contained within the US-UK treaty. But Fitzgerald insisted that it was a big step to say that this protection, which has existed in Anglo-American law for generations, has simply been removed by silence. It is unacceptable, Fitzgerald insisted, that the U.S. government should be able to seek Assange's extradition by way of an international treaty, while simultaneously arguing that the political offense exception within that treaty does not have any force of law. The choice by the U.S. government to seek Assange's extradition not only violated his rights under the treaty, but by extension represented an abuse of process and violated his rights not to be subjected to detention outside of the law, Fitzgerald concluded. Criminalizing ordinary journalistic practices. Prosecuting Assange for publishing leaked national security information would violate his rights to free speech. Such activity was and is legal and commonplace, because it is conduct protected by universally recognized and entrenched principles of free speech, Assange's lawyers declared. According to defense submissions, the courts always make a distinction between the obligations of journalists on the one hand and their sources on the other, a point which Bereitzer did not pay due deference. Assange has faced a legally unprecedented prosecution, which seeks to criminalize the application of ordinary journalistic practices of obtaining and publishing true classified information that was in the public interest. His attorneys recalled how the publications led the U.S. to cease drone strikes in Pakistan. The publications led the European Court of Human Rights to rule that Khalid el-Masri was kidnapped and tortured by the CIA. The publications led to U.S. military amending their rules of engagement in Iraq. Summers told the court that the publications even accelerated the end of the U.S. war in Iraq. Bereitzer emphasized in her decision that the UK Official Secrets Act also criminalizes publishing classified information without authorization. But as Assange's lawyers stated in their submissions, whatever the potential scope of the UK's Official Secrets Act on its face, it has, like the Espionage Act, never been deployed to prosecute, much less convict the act of obtaining or publishing, as opposed to leaking classified information. The core reason for that is because it would be fundamentally inconsistent with, and a flagrant denial of, press freedoms. As in the US, instances of obtaining and publication of classified information by the UK press are legion, but never prosecuted. In this jurisdiction, this prosecution would be, and extradition here facilitates, a flagrant violation of Assange's right to freedom of speech. Defense lawyers outlined jurisprudence from the European Court of Human Rights that sets out clear criteria for the protection of whistleblowers. Summers contended that U.S. Army whistleblower Chelsea Manning, who leaked the document, the High Court judges asked Summer whether it was the case that publishers were not prosecuted for publishing documents containing the names of sources, assets, and others. Summer replied yes, and cited the case of Pentagon Papers whistleblower Daniel Ellsberg, who was prosecuted under the Espionage Act. While Ellsberg was prosecuted, the New York Times, which published his leaks, was not. Summer also cited the example of Cryptome, which was the first to publish the unredacted diplomatic cables before Wikileaks. No one associated with the site has faced prosecution despite being based in the United States. Today's hearing was entirely focused on the arguments by the defense. Tomorrow's hearing will focus on the U.S. government's response to the request for an appeal. If the High Court accepts some or all of the appeal grounds as being at least arguable, they will set a future date for Assange's appeal to be heard. But if the High Court judges reject the defense arguments, Assange will have exhausted all of his domestic avenues of appeal. Assange's last option will be to file an urgent application to the European Court of Human Rights, which is in Strasbourg, France. We all await the court decision. Please subscribe. Please subscribe. Like, follow, and share. Don't forget. Thanks. The above was all alleged, and you should do your own research. No reliance should be placed on this information, and we exclude any liability for any reliance. The contents of this report are alleged. You should do your own research, and we shall not be liable for any reliance on the data herein.